What the Nottingham Inquiry is revealing is shocking and unacceptable. And as the government continues to drag its heels over Hillsborough Law, the Nottingham Inquiry is demonstrating every day it's in session the consequences of still not having a duty of candour. In June 2023, Valdo Callacane stabbed to death Barnaby Webber, Grace O'Malley Kumar and Ian Coates. Then he stole Ian's van and drove it into pedestrians, leaving 3 people with life-changing injuries. In court, he pleaded guilty to manslaughter on grounds of diminished responsibility and to attempted murder. He received an order to be detained in a high-security hospital because of paranoid schizophrenia. Questions of why and how Callacane was able to murder and maim are now being examined by the Nottingham Inquiry. It heard from over 70 witnesses so far and won't conclude until later next year. But what we can do now is to look at what the evidence is telling us about the urgent need for a statutory duty of candour in the UK, which is set out in Hillsborough Law as a requirement for openness, frankness and transparency at all times right across public authorities. And it is backed up by new criminal offences, including the offence of a public official misleading the public, up to 2 years in prison, seriously improper conduct, up to 10 years in prison, and breach of the duty to prevent death or serious injury, up to 14 years in prison. What we're seeing in the Nottingham Inquiry evidence is not just a litany of mistakes and misinformation being handed out to the bereaved and the injured. It's crystal clear that Hillsborough Law is urgently needed. Yet the government is already more than a year behind the deadline it set itself to get Hillsborough Law onto the statute books. It's astounded me to look at the evidence being given to the Nottingham Inquiry as evidence of the need for Hillsborough Law and its duty of candour, because this goes wider than preventing cover-ups and lies. Hillsborough Law might actually be able to stop travesties like this from happening in the first place. The first point that's really clear is there was inaccurate and misleading information from the police. Ian Coates' partner was told that he had died in a road traffic accident, and they carried that belief for hours before being told he'd actually been stabbed. Ian's son found out about the death of his dad on Instagram because the police didn't formally notify the family about what had happened until 10 minutes before they briefed the press. That is not openness, transparency and frankness. It's a shocking lack of candour that's saying something is very wrong with the culture of the organisation. Second is the evidence about withholding of information, again by the police. The police knew Callacane and they knew he had previously been violent on several occasions. There was an outstanding arrest warrant that hadn't been executed. They hadn't done anything about it, seemingly because they didn't think he would end up with a custodial sentence. But were they even thinking about the safety of the public? The Assistant Chief Constable admitted we could have done more to arrest him. But it's making me wonder whether the existence of Hillsborough Law's clear and specific offence of breach of the duty to prevent death or serious injury, an offence which is designed to apply to public officials, including the police, might have made a difference. Would that arrest warrant have been acted on if police officers were more cognisant of the potential consequences? Because it seems that the police didn't want to tell the families that they already knew Callacane and knew of his violent behaviour. The police withheld this information from the families. And withholding of information hasn't just shown up in the evidence from the police, it's also there in the evidence about the behaviour of the NHS. After the attack, families were trying to find out about the perpetrator's history and his treatment, but the NHS were not open. As Grace O'Malley Kumar's father has said, we couldn't understand why there was a total lack of transparency We wanted to know his history, whether the treatment had been good, effective, efficient. And it turns out it hadn't. The third point is about suppression of information. Was there an attempted cover-up by the police? Information about the police's knowledge of a violent attack involving Callacane in 2020 was omitted from official police briefings to the public. It was described at the inquiry as a mistake. When a local newspaper reported what the police actually knew about Callacane, including stalking allegations, known violence, the response wasn't openness. Instead, the force reported the journalists to the Independent Press Standards Organisation. That goes beyond withholding information. It suggests an attempt to suppress and to cover up, which makes me wonder whether the Hillsborough Law's new criminal offence of misleading the public might have served as a powerful disincentive. Fourth is evidence of misuse of information. Nearly 200 police officers accessed the files about these killings, and many of them did so inappropriately and without authority. It's a key issue for the families who feel it demonstrates that there's been no respect, no dignity, no privacy, and this falls well below the high standards of ethical conduct that are required under Hillsborough Law. We don't know all the details yet, because the police have only just begun their own internal investigation about access to CCTV footage and why. And messages between police officers in a WhatsApp group have disappeared or are missing. But we do know one officer, with nothing to do with the case, watched a video of Grace and Barnaby being put into body bags. And he watched that video from home, not even from the office. We know that because Nottinghamshire Police said that they'd sacked him for gross misconduct, but actually he'd resigned. It's another example of lack of candour and not being open and transparent about the actual facts. But I'm wondering, where is the line between gross misconduct and seriously improper conduct? The criminal offence that's for public officials that is clearly set out in Hillsborough Law. We can't know whether the police conduct would or could have crossed the line, and I'm not suggesting it has, but it is important to think how the criminal offences envisaged in Hillsborough Law and the duty of candour and the requirement for high standards of ethical conduct create a powerful recipe for culture change and for deterrent. And the prospect that that recipe might be enough to prevent disasters like the Nottingham killings from happening in the first place. Could Hillsborough Law have prevented these killings? We can certainly say that if Hillsborough Law had been in place, properly embedded and enforced, the pattern that we're now seeing unfold at the Nottingham Inquiry would have been very different, because public officials would know they were accountable. And it is increasingly difficult to ignore the delay by government in getting Hillsborough Law onto the statute books.